Welcome to another episode in our ongoing YouTube video series on employment termination and severance pay. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing the over-reliance in many respects of employers on confidentiality agreements from their previous terminations. Now, whereas it's understandable that they want to cover up the fact that they have terminated people in previous circumstances and paid them increased termination and severance pay. What they fail to fully understand, in my professional estimation, is the fact that those confidentiality agreements go to specifics of what those numbers are. And what they fail to address, and I believe in many respects employers become overly confident, overly reliant upon, is the fact that where there are discrepancies or errors in the way that they have determined aspects of their employees' payroll, whether it's termination pay, severance pay, or other aspects, that they become overly reliant upon the confidentiality agreement in perpetuating this system of underpayment. And it very much is so in larger companies where they have a process where they seek to underpay their employees, in particular employees who they have discharged, fired, terminated, laid off. And what they do is they effectively say that we'll start off low in all circumstances, fully recognizing, in my professional estimation, fully recognizing that they are underpaying and that there is both statutory and oftentimes case law that says to them that they have been underpaying these amounts, and letting the employees then proceed to have to engage legal counsel to challenge them, and then to get something that is less than what they are entitled to. And this is not a particular phenomenon to Alberta, to Canada. It goes the world over. Especially with these larger employers, they have such large, vast quantities of money and power, and they recognize that employees, especially when they've been terminated or laid off, are not in a particularly good position. So what do? They start off low, they're prepared to pay somewhat higher, knowing full well that the employees realize that now that they've lost their job, they can go in for a brutal legal fight, spend lots of money, and not have money for an extended period of time. And what does it do for them? It does them great financial harm. And with this recognition on the part of the employers and the employers' lawyers, they proceed with this, then they proceed to have them file suit, and after they file suit, they offer up some pittance. All subject to confidentiality agreements, all subject to releases that attempt to close out the process and preclude that individual from disclosing that, believing that there is no further disclosure that is possible from that point forward. And this is an overextension of where they believe they are superior, more intelligent, and the like, in my professional estimation, because they are forgetting a critical aspect in this whole process. And that aspect is that they now have imparted knowledge upon them that what they are doing is incorrect, inaccurate, and fails to follow and conform to statute and to case law. And they try to do this under the guise of they've never admitted that they're wrong, even though they've been brought knowledge as to the fact of the error in their ways. But they say, whoa, I may have been informed of this. I still don't believe it's correct. And what I'm going to do is I'm going to repeat this over and over and over again. So even though they have knowledge as to the fact that they are most likely, if not, transgressing the law, transgressing statute, transgressing case law, they go on to perpetuate this process. However, in my professional estimation, once again, there are limits to this. And there is recourse from those employees who recognize this and those lawyers who recognize that they've been operating under this process and trying to deceive their own employees, recognizing that they have to correct themselves. Because it's one thing to say that there is a gray area, but very often it comes to them, especially when it's a combination of statute supported by case law, that their processes are entirely incorrect. And yet they do not make any adjustment, believing full well that no one is challenging them on that. And that is entirely inappropriate. It is in many respects what one could claim unethical, and is clearly in violation of the law in my estimation. Nevertheless, people don't pursue them on this because they don't necessarily challenge them on all the appropriate aspects, because they now have knowledge from those past matters. And oftentimes they have realization that they are in violation of certain aspects, and nevertheless they continue to perpetuate those matters under the guise of these confidentiality agreements and under the belief that no one will be able to challenge them. But what we see now is there may well be an avenue, and I firmly believe there is an avenue through which employers can be challenged and can be put to task and can be shown that they had knowledge that they chose not to act upon, and therefore aggravated the damages which were perpetuated upon their employees, including yourself, where the circumstances are aligned and demonstrate that there is a factual pattern that can substantiate knowledge and an attempt to deviate from paying the full amount that is required based on statute and based on case law, and they had knowledge of it. And this is a very serious thing that has not been, in my estimation and my research, not been appropriately litigated, but is available to those employees, especially those employees who have been recently fired from jobs where the fact pattern aligns to this arrangement. So what kind of fact patterns are we looking at? Well, what we're really looking at in many respects are fact patterns where we have high-paying employees who work on an hourly basis, who have substantial amounts of bonuses, overtime, other remuneration beyond a base salary, and this is not being appropriately paid out. And that is the major concern that we see, and the major vulnerability that employers are positioning themselves in. So some of the industries that we see this in particular are in the oil and gas industry and in the mining industry, where employees are paid substantial amounts of money, but their base salary only represents a fraction, still a substantial part, let's say 70%, 80% of their employment income. Nevertheless, the other portion of their employment income comes from such things as allowances, bonuses, premiums, RRSPs, and the like. and those numbers add up. And then what the employers typically do in many of those circumstances in our research is that they are underpaying those hourly employees. And when they terminate them, they have attempted to walk away with a substantial amount of money that is legally owed to those hourly employees. And they are pocketing it for their own purposes, even though the law does not allow them to do that. And they are also doing that with the knowledge that we have spoken about, because they are operating on the belief that their confidentiality agreements in previous circumstances are protecting them from having to espouse that knowledge. And that, in my estimation, is a false belief. It has simply not been challenged sufficiently in the courts and has not been challenged sufficiently with the employers, because they apparently have failed to recognize that this is a particular aspect that needs to be pursued and sought after. So if you're looking to address such a situation, if you believe your circumstances with respect to your termination are such that they might match up with the fact pattern we're discussing, do not hesitate to contact myself, and we can discuss how you might be able to pursue those matters, and if the facts and circumstances in your particular situation align to allow you to pursue these kind of situations, because otherwise you will in most likelihood be leaving a substantial amount of money on the table, and you will not be having the full legal advantage that you can have to pursue your employer effectively. Well, it's really your former employer who just fired you and took money that is legally yours in these circumstances and kept it for themselves. So I trust you found this YouTube video informative. Please feel free to contact yourselves if you are interested in pursuing these angles. And we wish you all the best and look forward to speaking to you again. Thank you.